Settled between us
My lord,
means?
Miss Roy and the school authority, my lord.
That is between the school, but the
Yes,
petitioner is suffering.
my lord,
What
that
is your prayer?
My lord, prayer is, my lord, they have alleged unauthorized absence have been taken at resignation.
All right.
Then that can be permitted. First, my lord,
All right. So we can adjourn it because there is a prayer.
do that, your lordship. Do that, your lordship.
All right.
Otherwise we can't. My lord, would your lordship take it up on 21st?
virus of the rule also challenged.
I am not placing the virus. I will go that-
21st, immediately prior. 21st is a Sunday.
Oh, sorry, my lord. Any after 19th, any day convenient to losses. But before my lord, vacation, if
Why? What is so urgent that it has to be heard before the
But
vacation
if I place it,
2023?
for 5 minutes, your losses will
Then
understand.
place it in the next year. Let him also take instruction in the meantime.
And because of this, my lord, appeal has been adjourned in another matter. That's
What can the court do? The matter is there in the list. It's taken up. Request from the council. What
no,
to
no,
do?
I
My lord, 22nd, my lord, made.
22nd.
do that, your lord. Let
Please
us
come.
try, your lordships.
Learned advocate representing the
School authority, my lord.
school seeks accommodation. The prayer has been made to post the matter on 22nd December. Stop. List on 22nd.
No. নামগুলো দিন।
Yes.
Appealing for the commission bill.
Yes.
Probably my learned friend will take some time. I'm coming back, your lordship, because we both are in the same matter. I'm item number 4, courtroom number 14. I have to give short reply.
No, which one is yours?
Fine. You can take it up on Wednesday. Applicant.
Applicant.
Because I my lord, we remember the EWS matter. The simple point involved there here in my lord, that whether the last date, that is 21st September, that the last cut-off date will be applicable for EWS certificate or not. That's the law point.
Yes.
That the last cut-off date, that is 21st September 2025, in pursuance of the advertisement publication by the West Bengal Central School Service Commission, that would be applicable for EWS certificate or not. That is the subject matter in this writ petition, my lord. My lord, I want to hand it over the whole bunch of the certificate, EWS certificate, because although certificate is annexed, the government status.
Yes.
This shows the status of the certificate. Well, the last column, kindly see. Just one. Certificate valid from 2025-4/1. That means 1st April 2025 to
31st of March 26.
So EWS certificate, economically weaker section certificate, is valid for 1 year. Whenever any advertisement floated, they, in pursuance of that advertisement, they applied for getting the assets declaration. Thereafter, their verification, they got the certificate. My lord will remember on the last occasion, kindly turn page number 128. My lord, made a chart. When they applied,
Yes.
when they applied, page number 128 onwards, when they applied for EWS certificate and when they got it, I made a chart. Kindly turn page number 127.
What does the advertisement say? When is the date?
Last date. I will place the advertisement, the
Right,
respective rules.
127.
Yes, 127. Kindly see my lord, the particulars.
Yes.
Time limit prescribed as per the Public Service Guarantee Act, that is 28 days. So 28 days is the maximum days. Beyond that day, they issued the EWS certificate. Now, my lord, kindly take the rule, because I believe my learned senior friend, my lord, they will place the rules, and what they did, my lord, I place thereafter, my lord. Kindly take rule 2R, 21R, page number 120, sorry, only 24.
Yes.
Reserved category means a category of reservation in respect of scheduled caste, scheduled tribes, other backward classes, and physically handicapped candidates, and other categories of reservation, if any, enforced by an order of competent authority as at the last date of receiving of online application as may be notified pursuant to advertisement to be issued hereunder. Nowhere it is stated EWS. Now, my lord, kindly take the schedule 1, page number 31. Page number 31.
Yes.
Well, got it? The age limit column,
Yes.
the nota bina portion,
Yes.
the second nota bina portion, that is for consideration of application in SC, ST, OBC, PH. Got it, my lord?
Yes.
Categories. There is no mentioning about EWS categories. Certificate issued by the competent authority of only the government of West Bengal as on or before the last date of receiving online application shall be treated as valid document. There is no such mentioning of EWS because they know it very well. EWS certificate validity for a one particular financial year, because this all about asset declaration. I will place that rule later on, my lord. Candidate belonging to such category from other state will have to appear as a general candidate only without any corresponding concession, relaxation in respect of age, fees, and qualifying marks. So, there is no such mentioning of EWS category. They ought to gather the certificate within the last stipulated date. That too, only this rule applicable only for SC, ST, OBC, and PH. But what West Bengal Central School Service Commission conduct? But I placed one after another, my lord, notification. What they did actually. No, yes, notification. What they did, they themselves violate the rule.
Yes.
Kindly turn page number 165 onwards.
165.
The notice.
Yes.
The last, admittedly, the last cutoff, just before that, my lord, the last cutoff date, I just show it from the advertisement, although that is extended for 7 days. My lord, kindly turn page number 38. Before that, my lord, what was the last closing date of online application? Page number 38. Can one annex 21 can one to wait for closing date, my lord. Got it, my lord? The scheduled date, page number 38.
Yes, yes.
Closing date 14 July 2025. Later on, by a notification, they extended 21st July 2025. My lord,
Right.
that notification is not annexed, I believe.
All right then.
So, my lord, kindly thereafter kindly turn page number 165. So, last cutoff date is 21st July 2025. Whosoever declared themselves within that stipulated period in that 4 category, SC, ST, OBC, and PH, whosoever declared themselves, whosoever got themselves, they only considered SC, ST, OBC, or PH, no other candidate. Now, my lord, kindly see the advertisement, their notification. Addendum notice regarding edit option. This is to notify all concerned in connection with second SLST 2025 for classes 9, 10, and 11, 12 that in view of order dated 28 July 2025, the Honorable Supreme Court in SLP civil number 17422 of 2025, State of West Bengal versus Purabi Das and others. I will place that order, ballot. There is no such mentioning. You will extended the date beyond the last closing date. And other connected matter, the online portal will be opened for collection of category details from 5th August 2025 to 11th August 2025. They extend themselves, they extend the date by violating their own rules.
Hmm.
The candidate, I could say, violated the state government rules because that rule is framed by the state government. They are the mere statutory body, so they can't violate it. But they violated through this notice. The candidate will have to first log in and choose the edit option. Then he/she will have to select the category from drop-down menu. The candidate will also have to specify the subcategory, the applicable certificate number, and issuing authority in separate text boxes to be made available after category is chosen from drop-down if applicable. Any final decision will be subject to outcome of pending legal proceedings. Now, very next notice, that is page number 166. Very important, my lord. That is most important notice. In continuation, that is dated 5th August 2025.
Hmm.
In continuation of our earlier notice issued vide memo number such and such, that the earlier notice dated. This is to further notify for information to all concerned that all candidates, irrespective of their category, are required to mention their specific category within bracket. That is most important. Caste, class, EWS, PH. So they treated all this in same categories because that is the rule. That is the governmental notification. I will place later on. In respect of place in their application form through the edit option provided in the website from 5th August 2025 to 12th August 2025. So they enlarge the date by giving this edit option to throughout all categories. This is the first time because in first notification, I inquired it. First notification, there was two options. One was that SC, ST, and PH, and for others, whosoever, general, OBC, EWS, there was others category. They not mentioned general or unreserved or EWS. In the first round, up to 21st July 2025, every candidate, either they mentioned SC or ST or PH or all others. So there are four categories was there. Later on, by dint of this notification, they again all the candidates who are in other category, they categorize themselves in three categories. One is unreserved, another one is EWS, another one is OBC. But because of that OBC matter is going on, so my lord said later on, after last closing date of application, they themselves declared whosoever, even can one applicant also, in the first round when they fill up their form, they fill up their form by mentioning others. Later on, they by edit option, they fill up their forms as EWS because they're not annexed their first round online application. Now, my lord, very next, and one thing, my lord, through this notice, it is clear that caste, class, EWS, and PH, they similarly treated. It is evident from this notice. Now, my lord, very next notification. The exam conducted, the 9-10 category exam conducted on 7th September and 11-12, 14th September. After completion of the examination, they again issued another notice on 22nd September 2025.
Yes.
This is to notify all concerned that though opportunity for updating stroke editing caste category. So caste category means SC, ST, OBC, EWS, PH, then ETC, adjustum generis. That means any other categories have been offered to the candidates several times. A number of candidates have not yet updated their categories in their application forms. Therefore, a last opportunity is being given to the candidate to update the same in their application for second SLST within bracket 80-2025 for classes 9, 10, 11, 12 from 22nd September 2025 to 26th September 2025. So, after examination, by violating the rule, they give opportunity to all caste categories, 7 except EWS. The candidate will have to first log in and
No, it's all right then.
so my lord, that is the rule position. So last
Yes.
all the candidates, herein, all the petitioner herein, they gathered their EWS certificate before that last cut-off date. 26 September 2025. All
So
the
they did not edit?
they not give the opportunity. That's my case. They give opportunity by this notice to only the OBC candidate, no other candidate. That's my case. And they says, kindly see the last order, my lord's last order, 10/11/2025 order, para 8. In my lord's order, para 8.
Hmm.
However, this bench has not been made order passed by the Honorable Supreme Court with regard to direction issued in respect of SC, ST, OBC category, extending the time limit for submission of candidate. Let the order passed by the Honorable Supreme Court or any other court be placed before this bench on the returnable date. This says, due to Supreme Court order, they extend that day only for the OBC candidate, no other candidates. My lord. And my lord, today I believe they apprise this court by that order, whether Supreme Court says beyond, after examination, violating the rule. Now, my lord, I just want to place, my lord, to judgment, my lord, which supported my contention. Even if I got EWS certificate before verification, ought to treat me as a EWS candidate. Although I get all Haryana division, Haryana division. তারপর সুপ্রিম কোর্ট এখানে আমি বোধ দিচ্ছি কপি Haryana Staff Selection Commission, my lord, by quoting that, my lord, Doli Chanda, my lord, will have the fact, my lord, and Ram Kumar Girija quoting, my lord, may I place that, my lord? But because this is a division, ultimate, that went up to the Supreme Court and Supreme Court upheld it.
Does this matter relate to EWS?
EWS, my lord.
Show me which portion.
My lord, kindly the first, my lord. So they denoted it as a special backward classes. My lord, this letter patent appeal is, my lord, last paragraph, that while making the said application, respondent number has claimed reservation under special backward classes category, though he also claimed eligible under economically backward person in general caste, EBPGC category. Respondent number 1 is called for scrutiny of document to be held on 29th August 2018. At that time, he produced EBPGC certificate issued by the welfare of scheduled caste and backward classes department on such and such, on the ground that the advertisement contained a condition that the said certificate should also have been issued prior to the last date of submission of online application form, that is 12/10/2015. The respondent number was not given the appointment letter. So they ought to place it before the last date. That's the factual matrix, my lord. Respondent number 1, therefore, my lord, I just skip it, my lord, that it is mentioned in the same fact, on the same fact, my lord. By quoting that, I just want to, my lord, this is supplied. My lord, page number 6. That Dali Chanda, my lord, I place the Dali Chanda and Girija also. The general rule is that while applying for any course of study or a post, a person must possess the eligibility qualification on the last date fixed for such purpose, either in the admission brochure or in application form, as the case may be, unless there is an express provision to the contrary. There can be no relaxation in this regard. That is the matter of holding the requisite eligibility qualification by the date fixed. This has to be established by producing the necessary certificate, degree or mark sheet. Similarly, in order to avail of the benefit of reservation or weightage etc, necessary certificate have to produce. These are documents in the nature of proof of holding a particular qualification or percentage of marks secured or entitlement for a benefit of reservation. Depending upon the facts of case, there can be some relaxation in the matter of submission of proof. It will not be proper to apply any rigid principle as it pertains to domain of procedure, because I applied for the certificate much before the last cut-off date. Every infraction of the rule relating to submission of proof need not necessarily result in rejection of candidature. So Dali Chanda, I produce the Dali Chanda as well as the Ram Kumar Girija also. Ram Kumar Girija also quoted here in page number 4, my lord. Ram Kumar Girija also an ultimate. The court hold, my lord, page 9 onwards. The said judgment does not apply in the instant case because of the instant case. The time of advertisement, respondent number 1 could not claim under both SBC category and EPBGC category, claim reservation under SBC category because it was necessary for him to seek reservation in the BPGC category as well. But without his knowledge and behind his back, the appellant has decided not to give reservation under SBC category. In this circumstance, the appellant cannot also contend that respondent cannot seek reservation under EBPGC category, although they got this certificate much after the last cut-off date. This is thus no necessity to doubt the genuineness of the same because it would have been issued after verification process by the competent authority. In fact, according to the respondent, the district administration was not issuing EBPGC certificate to eligible candidates who come back from SBC to EBGC category. That means that in our state, that is EWS category. And the district administration had started to receive the application for issuance of EBPGC certificate only when instructions were issued on such and such date by Chief Secretary, Government of Haryana, and only thereafter the respondent was issued in such certificate. So the respondent number 1 cannot be blamed for not claiming reservation or not producing certificate under the said categories such and such date. He could not have complied with the requirement because it would have been impossible for him to do so. The decision in such and such is with regard to determination of age of the candidate for selection by fixing a specific date of time. Thus, it was case of possessing a necessary eligibility condition, but not a case where a claim of reservation is made. As pointed out for the letter, proof of reservation claim can be submitted later. The decision of Ms. Rekha Chaturved is also one applicable of possession of essential qualification by a cut-off date and is not a case dealing with a claim for reservation like the instant case. The decision cited by the counsel for the appellant are thus distinguishable because qualification for holding a post is certainly to be decided on the basis of the cut-off date fixed in the admission, but for availing benefit of reservation. Production of certificate issued before the cut-off date is not necessary, and there is no such rigid principle as held in Dolly Chanda versus Chairman J. Ispra. So, in the peculiar facts and circumstances of the case, we are of the opinion that no case is made out for interference with the judgment of the learned single judge. Accordingly, the appeal is dismissed. So, my lord, no rigid principle ought to applicable. Because of that, my lord, we applied much prior to the last cut-off date. The lacuna of the Article 12 authority, we got it, that too within the last cut-off date, that is 26 September 2025. They not allowed us. This case, my lord, went up to Supreme Court. Now, my lord, Supreme Court also appealed. Supreme Court arekta copy though.
Yes, it is here. Supreme Court.
Oh, sorry, my lord. And that is our ultimate, my lord. I have not placed it the whole portion. Maybe. The appellant here, Haryana State Selection Commission published an advertisement on such and such date, inviting application for the post of PGT. The closing date for submission of online application was 21st September 2015. The last date for deposit of fee by the candidate was 24th September 2000. The advertisement itself specifies the post reserved for the various category, including SBC, special backward class, and EBPGC, that is equivalent to EWS, 5%. The first respondent specifically applied under the SBC category for the post of PGT in political science. It appears that on 29th August 2018, the first respondent was informed that he was qualified in the written test and therefore he was called for scrutiny of document. In the result declared on 17 September 2018, the first respondent was shown in the general category. The first respondent secured total 118 marks. The cutoff in the general category was 120 marks, and therefore the first respondent was not selected. It appears that Government of Haryana issued communication dated 21st February 2018 and 1st June 2018, recording therein that in view of the order passed by the High Court in such and such, the notification dated such and such should not be given effect. The said notification dated 27 September 2013 Secretary was for providing a quota to the candidate belonging to the SBC category. On 5th June 2017, a certificate was issued to the first
All right,
respondent
I have
reporting
followed.
that belonging to the
Yes, I
EBBC
have
category.
followed.
So, my lord, that is the factual matrix, my lord. Thereafter, para 10 onwards, my lord, I just skip it, my lord, because of that it is mentioned, my lord. Following that Dali Chanda and Ramkumar Girija, my lord, I just for my lord 2016 4 SSC Ramkumar Girija. I just
It has
not,
been
my lord, place that. I just place
Ramkumar
4 paragraph. Ramkumar Girija 2016 2005 9. My lord,
That is regarding the
2005.
caste certificate.
Yes, my lord.
The caste. Do not give the caste one. It is only EWS.
But that principle and analogy was taken.
Yes,
But
yes.
2005 9 SCC 779 para 7 and 2016 4 SCC 754 para 4 14 and 18.
But there is a little bit of difference between a
Yes,
caste
yes. My lord, no
certificate
doubt
and
about
EWS
it.
certificate.
Because of that, my lord, EWS certificate. I just, my lord, summarize my submission that, my lord, EWS category is a unique category. But because of that, this benefit wants to given within the unreserved category who are economically backward, and that to ascertain each financial year, my lord. And that's why, my lord, after floating the advertisement, they applied for that EWS category, although there is a stipulated time, but due to laches on the part of the Article 12 authority, my lord, I got this EWS certificate after, my lord, last cut-off date, my lord, which is mentioned in the advertisement, but before the last cut-off date, subsequently by the notification, that
Very
is
well.
for 26 September.
Very well, very well.
That's my case, my lord.
All right.
It will be
Yes.
kind enough if, my lord, consider
Commission,
all the
please.
petitioner as
Yes.
a WS category.
But kindly come to page first 44.
May I take my lord, leave
Yes.
because
Kindly
44.
come to page 44.
Yes.
But your lordships will find from there the category has been described as general.
Yes.
All are general category, they have made this application. C46 also.
At the time of floating the advertisement, was there any reservation for EWS?
Yes. The lordships will find from the advertisement to the page. Kindly come to page 37. Income tax. Income tax. At the bottom. But kindly just. It is 11.
Page 39, I can see.
Page 39, lordship has sent it.
Fees for the examination.
Fees
It
for the
mentions
89 rupees 50, a silka type PH.
and general and OBC. There is no EWS.
No, OBS, category has been, category one has to say, if he wants to get the benefit from the EWS, then EWS category has to be set.
Where is that category in your application? In the
Right.
advertisement?
Then they are not entitled to get it.
Show me from your advertisement.
If it is not in if the advertisement it is not there, then how they can get the EW category? We have made
Very well. Very well. In that case, your addendum notification.
Yes, that's right. Milord, I will, in that case, I will file also affidavit. Milord, kindly come to the note first, page 41. And there are so many candidates, those who have submitted their form in EWD categories. But for consideration of belonging to reserved categories, the certificate issued by the competent authorities of only the government of West Bengal on or before the last date of receiving online applications shall be treated as valid documents. Well, that has been extended. But kindly come to page 165 first. This is to notify all concerned in CW2 second SLST class 9 and 10 that in view of the order so and so or in SLP so and other connected matters, the online portal will be open for collection of category details from 5th August 2025 to 11th August 25. The candidates will have to first log in and choose the edit option, then he shall have to select the category from the dropout. Now, next is kindly come to page 166. In continuation to earlier notice issued valid memo number so and so dated 30th July 2025, this is to further notify for input to all concerned that all candidates, irrespective of their category, are required to mention their specific category, caste, class, EWS, PH, etc. in the respective place in their application form through the edit option provided in the website from 5th August 25 to 12th August 25. And EW has been set up to 12th August 25. Next, my lord. Page 167. This is to notify that 22nd September 2000. This is to notify that all concerned, though opportunities for updating caste category have been offered in only this is a case of a caste category, not the other categories. Caste category have been offered to the candidates several times. A number of candidates have not yet updated their categories in their application form. Therefore, last opportunity is being given to the candidates to update the same in their applications. So and so. The candidates will have to first log in, choose the area, this way we will have to select so and so. In case of any candidate fails to update his category within 26 September 2025, the category of such candidate will be treated as general. Therefore, this is a caste category concern, it has been extended. So far, EWDs, it was not extended. EWD and PH. Now, this has not been done. Now, when they have given it, kindly see the page is certificate, kindly see. No. Kindly come to page 48. This is on 18th September 2025. Long after. Valid for the year 2025 to 2026. Instead of so and so, whose photography that is so and so, the weaker section of his family is below so and so for the financial year 2024. His family does not possess so and so. But this is dated on 18th September. Next one, kindly see 55. That is also 18th September. All are after that. Therefore, this is not in terms of just kindly give me 1 minute time. Rules to work on reservation. These are other categories. Now, kindly come to rules, page 32. There may not be there for consideration of application in SC, ST, OBC, PH categories. Certificate issued by the competent authority of only the government of West Bengal as on before the last date of receiving online applications should be treated as valid documents. Candidates belong to such categories from their states will have to appear as general candidates only without any swans. This is the reservation clause I have shown to you. Now, my submission first would be that that these certificates were not given within the time specified, long after. And your lordship, I will show to your lordship, your lordship's order, your lordship has dismissed the writ petition on that ground also. But the judgment which has been cited to your lordship, that Rajasthan judgment system, Rajasthan, Punjab, Haryana, your lordships will find, interestingly, I don't know, nobody has noticed it in the Supreme Court. Application was filed in 2015 from the judgment of the EWS. My lord, this benefit has been given by constitutional amendment of 103 in 2019. EW was not entitled to get in 2015 at all. Nobody has argued that point. Nobody has brought this notice within the Supreme Court. This has been notified. I just give your lordship's date. The Constitution 103rd Amendment Act 2019 was given effect from 12th January 2019. Therefore, I don't know, I will submit that judgment was completely ignorance of the constitutional amendment. No one was entitled to get it. Now I come to your lordship's, two judgments I will cite to you. This is the main factual thing in this matter. And if required, I will file also have an affidavit. And other CWUs have filed the application with their category of EWD. Now, how can I give it? But there is a form to one of my junior, if it is there. Can you see the Supravar Manto? Do you have, Mr. Bhattacharya?
Yes.
Can you see? There he has described himself as category EWS.
Later on.
But similarly, others have also filed EWS.
Later on. When?
Mr. Samim, I know you are more knowledgeable than me. Kindly allow me to speak.
No, sir, I am not saying.
No, you are. I am hearing you. When, how? I know you are the most tallest lawyer of the Calcutta High Court. Allow me. Now, let kindly see. These are in the application form itself. An application fee, see, 500 rupees. It has been given. Now, I will cite two judgments, including the judgment that both the 2009 and 16 has been considered. Kindly come to me, Lord, the judgment. Kindly come to similar 224 1 SSC page 448. That matters also relates to economic, kindly at the top, economic backwardness plus EWS categories. Kindly come to paragraph 49. In Gaurav Singh's case, it has been categorically held that assets for the particular financial year prior to the year of submission go to the root of the eligibility of the candidate in the DW. It has been further held that the candidates whose INSs are not in order did not have any legal right to be considered. It has also been held that no candidate can claim any legal right for reconsideration of the candidature by submitting a fresh certificate and or rectified certificate. There's a fundamental distinction, etc., etc. Then we'll kindly come to paragraph 51. It is also very well settled that if there are relevant rules which prescribe the date on which the eligibility should be possessed, those rules will prevail. In the absence of rules or any other date prescribed in the prospectus advertisement for determining the eligibility, there is a judicial chorus holding that it will be the last date for submission of the application. Here we have extended it. Now, kindly come to, paragraph 50. There is a fundamental distinction between Charles K. Sarid line of cases and the case at hand. As pointed out earlier, the eligibility for being categorized of EWS candidate crystallized only when the INSC is issued. And in this case, as required under the rule, it was to be issued and possessed by the candidates before 22nd September 2022. Now, my lord, kindly come to paragraph 58. In this case, rules clearly exist in the form of CSD. It has also been settled that determination of eligibility cannot be left uncertain till the final stage of the selection. Since that would be to uncertainty, further it is well settled that if rules prescribes the last date on which eligibility should be possessed, any relaxation would prejudice non-applicants who for want of possession of eligibility would not have applied. Then relaxation would then be selective, leading to discrimination. Then kindly come to paragraph 61. The strong reliance placed on Ramkumar Grijoria and case also does not impress us. Not only was there no rule like we have in the present case, it was only while declaring the result, the requirement of submitting the OBC certificate before the cut-off date was introduced by the selection authority there. Moreover, unlike the present, there was no contention or issue raised. In that case, the eligibility ensures or crystallizes only on the issuance of the certificate and on possession of the certificate before the prescribed cut-off date. But this is the judgment, Miller. Another judgment, Miller, I will show to your lordship, Miller. That is a
63, kindly to pull.
63. Okay. Apart from all this, the correctness of Ramkumar Grijoria case was referred to a three-judge bench in Karan Singh Jadhav. A perusal of para 6 of the referral order clearly shows that the bench was echoing the ratio of the three judges bench in Ashok Kumar Sharma's case, though there is no express reference to the said case. However, when the matter came up before three judges, the reference was not answered. And even after noticing that the Ramkumar case was so, the court, however, denied relief to Karan Singh Yadav, particularly holding that since the application was never appointed to the post at the length of the, it was not possible to grant any relief so and so. Then, Millard, kindly come to Millard. Next judgment I will show to right, Millard. Millard. Although it's a caste certificate, 2024 2 SSC page 716. Sorry, Millard, 2025 SSC online. 2025 SSC online. Paragraph. SSC online page, Millard. 716. 2025 SSC online page 1125. This is Mohit Kumar appellant versus State of Uttar Pradesh. Bench presided over by Justice Datto. Have you handed over? Mr. Bhattacharya?
That copy is not there with us.
Are bhai, show it from the iPad.
It was just now sent. Copy korte pathano.
You read out the portions. I can follow.
Kindly,
follow.
Kindly, sorry, kindly excuse me. Well, paragraph 14. What follows from the above decision is that irrespective of whether an aspirant for public employment belonging to a particular community like SC, ST, OBC, the status claimed by him for being accorded the benefit of reservation is per se not decisive. Such status has to be certified by the competent authority upon following due process and identification that the aspirant is what he claims to be. In Srinivas Prasad Shah, the requirement of production of a certificate from the competent authority was held to be mandatory in view of the statutory mandate. Although there is no such statutory mandate in the facts of the present case, the requirement in question no less mandatory and must be scrupulously followed. Once a process of recruitment is set in motion, all aspirants are entitled in law to equal treatment. There cannot be different yardstick for different sets of aspirants. Non-compliance with the terms of abdomen notification is bound to trigger adverse consequences of rejection of the aspirant's claim. Status by the selecting body appointing authority should be choose not to adhere to the same. Having regard thereto, the selecting body appointing authority would be justified in not entertaining the application of an aspirant as a member of the community for whom reservation are permissible. And another one paragraph. The proposition of law, next paragraph 15, as settled by the above decision does not appear to have been doubted in any subsequent decision, and we do hereby endorse the same. Well, this is the, and paragraph 19, it is no longer res indica that terms of an advertisement issued in connection with the selection process are normally not open to challenge unless the challenge is founded on the ground of breach of Article 16 of the Constitution for the matter. Article 14. Once an advertisement is issued inviting application for public employment, it is a responsibility, nay, duty of an aspirant to read and note the terms and understand what his requirements are. If any aspirant finds any of the terms ambiguous and there is a scope for an inquiry inbuilt in the advertisement or provided by any rules or regulation, an effort of to be made first to obtain clarify for understanding the requirements accurately. If no such scope is available, prevents the aspirant from seeking clarity. Should such clarity be not provided, the aspirants may participate in the process without prejudice to his rights and may question the term even after he is not selected. However, if the aspirant does not make any such effort and takes a calculated chance of selection based on his own understanding of the disputed term in the advertisement and letter, he emerges unsuccessful ordinarily. He would not be open to him to challenge the selection on the ground that the disputed term is capable of being understood differently. In such cases, the court should be loath to entertain such plea of ambiguity while preferring to accept the recruiting authority's understanding of the said term. This is for the simple reason that the recruitment authority is the best judge of what is requirement and are what in such understanding of the recruiting authority that would matter most in cases brought up before the courts. Hence, after commencement of the process, wherein aspirants have participated without raising any demur as to what particular terms means, even if of the terms be ambiguous, the court should lean in favor of the recruiting authority. My lord, your lordships have delivered passed an order on 26 November 2025. Tanmoy Maiti. The petitioner participated in the second SLST 2025. Prior to filing in his application form, he applied for a certificate under the economically weaker section category. This said certificate was issued to him on September 10, 2025. Grievance of the petitioner is that despite opportunity by the commission to update the details of the candidates in the concerned portal, such portal did not provide any option for updating the EWD's category of the candidate. It has been submitted that petitioner is an extremely meritorious candidate of physics and he should be permitted to avail the benefit of reservation. Submission made by the petitioner is opposed by the learned counsel representing the commission. It appears that the result of the written examination and the interview list has already been published by the commission. The petitioner, for any reason whatsoever, was unable to upload his reservation certificate within stipulated time period. Had the petitioner approached the court at the very first instance, when he was unable to upload the document, the prayer for the petitioner could have been considered. At this stage, allowing the prayer of the petitioner for updating his reservation certificate may amount to unsettling the interview list prepared by the commission. It has to be kept in mind that the selection process is being conducted by the commission in compliance of the direction passed by the Honorable Court, and a deadline has been prescribed for finalization of the same. In view thereof, the prayer for petition cannot be allowed. Well, these are my submissions.
When was the result declared?
Result declared 7th November.
Mr. Shanal is also there.
I've come up probably right time.
Mr. Sannal,
Are you?
Is he appearing? In which matter?
Can one.
Can one কি আছে? Can one?
এই তো।
Can one কি আছে?
ওখানে বলতে পারিনি, তুই এলে বলবো, আমি বলতে পারিনি, চলে এসেছি। কি করে বলবো, তোর কেউ নেই না, কেউ ছিল না। তাহলে
He has applied for addition of party.
যাস না, তুই এখানেই করবে। আমি বলছি দুটো সময়।
But he has applied for addition of party. We will file our affidavit in that.
They are opposing the writ petition, is it?
Opposing the writ.
Oh, they are opposing. I don't know. Sorry. One request can I make to your lordship? It's
Yes.
just excuse me. But today I am very badly pressed. But item number 7. Today and tomorrow I am very badly pressed. But item number 9. 9. Item number 9 can be taken up on Wednesday or Thursday. This is my request only.
Who's there in 9 and 10? 9 and 10, you say?
9.
9.
Only
Only
9.
9. Only 9.
Who's
Others
there in
matters,
9?
but just I inform you also whenever
But I think Mr. Dasgupta will be there.
just kindly accommodate. I am very badly pressed.
All right. As and when it is called up, just remind. Let me see what can be done.
Can I, with your lordship's leave, can I go?
Yes, yes, yes.
Well, I will be very, very concise because it might be in all probability will be the same submissions might be. But just your losses to
Same
point out.
submissions as that of the
Commission, I believe.
commission.
That may, my lord. I mean, just, my lord,
Who are the applicants?
the applicants are already declared as EWS candidate and they have applied
All right.
before the date of notification for recruitment. They
So you all were holding the certificate prior thereto.
exactly. Now your
You
losses
want to oppose them? Because if they are
Exactly.
added, then your
will, in,
chances get
no,
minimized.
my lord, in that, my lord, this is in a way look into this. My submissions, ineligible candidates is allowed to participate. That will affect my interest. They are ineligible on the date of publication of the notification. Why I just that will tell you. My lord, the page 24 of the writ petition.
Yes.
Now, my lord, definition clause R2.
24 of the writ petition.
This should be 2R.
Yes, the definition. Yes.
Your losses will find means a category of reservation in respect of other categories of reservations, if any, enforced by an order of competent authority as at the last date of receiving applications as may be notified pursuant to the advertisement. So therefore, they have to hold that certificate by the last date of receiving online applications. That they do not. Then your losses kindly see the same clause at page 141. Notification.
The submission of the petitioner is that the authority went on extending the time. It is not that the petitioners seek extension.
That is absolutely factually wrong submission.
The addendum notices are there.
They applied for certificate even after the notification.
Yes.
That's your losses.
Page 128.
Give an example, your losses. Page 128. Kindly take note of the fact that the recruitment notification dated 30th May 2025. Now your losses will find, and last date was 21st July 2025. These are the two dates. Now take one or two example. Your losses will find first name Mamata Samanto. In respect of her application from the bottom Mamata Samanto's particulars. Second one, online application date EWS 7th August 2025. So it is the after the notification. This is the chart kindly have a look. And if your lordships see income certificate issue date 18th June. So he prepared himself or herself even after notification and applied. These are the particulars required documents. He started collecting that during the process started and ultimately applied online application when the time was over. So how could he say that this is the fault of the authorities? This is his own fault. Similarly, your lordships will find the next one, Shumon Jana, 17th August 2025. Now your losses will find the Arup Pal, 24th June applied after the notification issued. Everyone applied either after the last date or during the recruitment notification. Most of them after the last day. Kindly, Milord, your losses may consider it. Your losses will find Joroth Karupal, page 129, 10th August 2025. So one or two might be here and there, but that's Milord, is a jumbled up. He should have made it one for one if you write for him also Milord, separately. But that case, now Milord, delayed eviction, this is one case. This is not correct. Now delayed by the authority cannot be imposed upon the other authority. One has to get it. Suppose your lawsuit's result published after the application. Lord, can he take the result published application? Therefore, I should be allowed to submit. This cannot be, Malad. This goes against the rules. Rules say so. Rules, there is no Malad relaxation clause. Doesn't have. One has to go by the rules. Now, there are your lawsuits will find page one example, Malad. Page 79. Kindly come to your lawsuits.
না, যে কোনো একটাতে হতে হবে।
Yes.
Now, your losses kindly consider this candidate already belongs to OBC B category. How can he apply for EWS? He cannot. He already belongs to either one. He can get. So he already belongs to OBC B. So these are the factual and rules. Say so. Notifications and resolutions. Oh, then it's okay, Malad. The other কিছু তো নেই। এটা part of the petition নয়?
না, এটা পরবর্তীকালে ইয়ে দিয়েছে।
Just a second, No, Malad, I don't know factually. Malad, I take your losses. এটা ওকে একটা কপি দাও, নালে কি করে হবে? This is your losses, kindly take. Issued by the commission. That's different. Malad, kindly have a look at the note 1. Malad, this is issued by the commission. All the above documents should have been issued on or before 21st July 2025. But as I placed before losses, most of them are not. One or two exception might be there. But that is good. Kindly see then. In case of continued EWS, but that case is not here. The application before the competent authority should be on or before 21st. That's the last date. Malad, suppose Malad, I have already a certificate that is going to expire. If I show an application that I have made it in between, then I can be allowed. This is the. So this is not the case here, lawsuit. But this should not be also there. We are opposing on this. The one, if you have Malad knows that it goes to July, and suppose your lawsuit ends on 21st July or Malad 15th July, it's not sure that he will be given again. Then how can he be allowed to be applied by the commission? Clear to your lawsuits. EWS certificate because of income of the family. Next year I may not have it. This is a very, very privilege given to the candidates. One should not misuse it. Because his misuse, because of his or her misuse, someone will be deprived. So this is martial law. That's good. These are my answers.
May I start? Because Mr. Khanna's presence is required.
No, wait. State is there.
One, Malad, only to what Mr. Bandopadhyay has already submitted, Malad. I'll just add one sentence to that, Malad. My learned friend for the petitioner has relied on Haryana staff selection. Malad, your lordship will find in the internal page 7 of that order, Malad, the Honorable Supreme Court, I'm sorry, Malad, I stand corrected. The Punjab and Haryana, the High Court at Punjab and Haryana has been persuaded by two judgments of the Honorable Supreme Court, internal page 7. One is Ram Kumar Gijroya and Charles K. Skaria. Now, Malad, Charles K. Skaria has been distinguished in the judgment cited by Mr. Bandopadhyay in paragraph 50.
1-5?
Yes, Malad, the first judgment which was shown, 2024-1, SSC 448, Divya. In Divya, if your lordship kindly comes to paragraph 50,
50, yes.
Charles case Karia Malad has been distinguished that why those line of cases need not be followed. And Malad Ram Kumar Gijroya, if your lordship kindly, this was referred to but not cited by Mr. Bandopadhyay Malad, Karan Singh Yadav, 2024 2 SSC 716. By this judgment, Malad, Ram Kumar Gijroya was referred to a larger bench. After Malad departing with the view in Ram Kumar Gijroya, and also Malad, two paragraphs will be relevant there if your lordship kindly takes Karan Singh. 3 paragraphs, Malad. From paragraph 4, we have heard the learned counsel on both the sides and perused the record, including the judgment of this court in Ram Kumar Gijroya. In Pushpa, which was referred to in Ram Kumar Gijroya, though the applicant had moved an application much prior to the date of the advertisement, the office of the competent authority took considerable time to make required OBC certificate available. It was in such circumstances that the learned single judge of the Delhi High Court held that the applicant cannot be made to suffer for lapse on the part of the SDM office in issuing the OBC certificate. In Gaurav Sharma versus State of UP, a full bench of Allahabad High Court disagreed with the view expressed in Pushpa and held that even claims made under the OBC category are to be made before the cutoff date prescribed in the advertisement. In Rakesh Kumar Sharma versus State, this court held that the eligibility criteria or condition are to be considered on the date of receipt of the applications. In view of the acute problem of unemployment, whenever few vacancies are notified by any public authority, it is common that thousands of applicants apply for such posts. If the applicants are permitted to rectify applications after the cutoff dates, the same would render the scrutiny process indefinite. In course of such recruitment process, many persons, though they belong to the OBC category or SC category, might not have obtained the required caste certificate before the cutoff date. Such persons, being law-abiding and being conscious of the bar contained in the notification of the cutoff date, might not have applied seeking employment. In case the authority starts accepting caste certificates subsequent to the prescribed cutoff dates, whenever a candidate approaches the authority, the remaining candidates who had not applied would definitely be affected. If the applicants are allowed to submit certificate in proof of their claim of reservation subsequent to the notified cutoff date, it would create administrative chaos. In practice, for every advertisement, there are such belated claims claiming reservation, though the candidates did not submit certificate from the competent authority before the cutoff date. In view of the general importance of the question, we are of the view that the issue which fell for consideration in Ram Kumar Gijroya requires to be considered by a larger bench of 3 judges. Accordingly, we refer the matter for consideration by a larger bench. Therefore, both the foundation has been doubted by the Honorable Supreme Court subsequently of the Haryana staff selection judgment. The other point, and even this Gaurav Sharma versus State of UP has been looked into by the Honorable Supreme Court in 2025 SSC online, which we are giving a copy, the commission is giving a copy in the course of the day.
All right, in reply?
In reply, I start from Can 1 application.
Yes.
In page 26 and page 27, some of the applicants, online application is there, I believe. And they mention EWS. First question, when they mention? Before 21st July 2025 or after 21st July 2025? Because my answer is very simple. And because of that dint of the 30 July 2025, first time they introduce this class, not before that. Because SC, ST and PH, these 3 category, and others was mentioned, all others.
How can an advertisement, the application has been shown where category EWS is mentioned on the day of the application?
After 30 July. That is edited application. That is after 30 July 2025. Again, I might place the notification.
No, don't place the notification. The application date is 10th of July. And this is after.
It shows, my lord.
Where is it?
Edited. It is fact, my lord. Edited.
This one, please show that this is edited, Detective Dinto.
We have given a copy to madam.
You have?
We have given a copy. Form a copy to dilo.
Suprabhat Mahanta?
ওই তো গোপাল হাতে এটা কি
না এটা না যাই হোক
the category is
my instruction is that, my lord. Now, my lord, my instruction is so. Now, my lord, I just kept aside which my learned friend, my lord, Mr. Shanal, my lord, and senior friend, placed that document verification. Kindly take it. That document verification. What The state did it.
বসুন, 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 আচ্ছা।
Even SSC did it.
The cost of that is not edited.
No.
The EWS is, they have given.
From the very first.
And the writ petition is pending before court number 25, my lord, where the
Oh.
contention of Suprabhat Mandal is that I had filled up the form, but I was not provided with the certificate with
For the argument's sake, my lord, I accept it. Now, my lord,
I know.
what is the rule? In rule 2(1)(r) says reserve category will consider up to 21st July 2025, not beyond that. Now, my lord, what they did it in their document verification format, kindly take which my learned senior friend my lord handed over.
Yes.
My lord, the first note. All the above documents should have been issued on and before 21st July 2025. Stop here. Thereafter, my lord, in case of continued EWS, the application, whatever the application before the competent authority should be on and before 21st July 2025. The mere application, they accept it. So that is,
But then that is a continuation, continued EWS.
yes.
Is any of your case a continued EWS
And
case?
it will establish if they give opportunity. There is no such mentioning of continued EWS. There is no
One
such
minute.
provision.
In any of your petitioners.
I have to take instruction, my lord. There is no such provision. My contention is that, my lord, there is no such provision. Give one instances from the statute. There is any provision of continued EWS. There is no such provision of continued EWS. Why? My lord, kindly turn page number 105 of my writ petition. It never be. And I will place the central government FAQ as well as the state government FAQ. My lord, kindly take page number 105. It never be. This term never be used in the case of EWS, because EWS is a 1 year. My lord, kindly take it. Certificate number, got it. Date now valid for the year such and such. That is financial year. So any certificate that is for a particular financial year. So there is no such terminology used in continuous EWS. Number one. Number two is that, my lord, what type of document it's required. My lord, from when you ascertain as a EWS. Kindly turn page number 118-19. That is what. Take 119. আর্থিকভাবে দুর্বল শ্রেণীর শংসাপত্র পাইবার জন্য প্রয়োজনীয় নথিপত্র. All this, my lord, we have to gather. What we have to gather, my lord, kindly see. There is a income certificate entry 9. So it starts from income certificate from the panchayat. So, my lord, it is required. And not only that, my lord, I also annex the memorandum of the West Bengal government, page number 120, and the FAQ regarding economically weaker section in force and service under central government. Both I annex, my lord. From that memorandum itself, it is evident the validity of EWS certificate entries para 7, page number 121. Yes, my lord. EWS certificate is valid for the financial year of issuance certificate. Same unit. Well, got it. Para 7, my lord. And my lord, my learned senior friend, although I instructed that this says in the adverse reservation. So if necessary, we will not give the benefit of that. They can't say so.
No, they are not saying so. They are not saying.
It is instruction, my lord.
No, they are
Yes,
not
yes, yes.
saying so.
My lord, kindly see, my lord wants to know that whether the all others is mentioned. Kindly see same person's online application. Sumanjana.
Same page, my learned friend referred 122. My lord, Mr. Sanyal said that OBC, if one have the OBC, my lord, cannot be reservation for EWS. That is also mentioned in 120.
Yes, yes, I will deal it. I will deal it. My lord,
No, I
kindly,
did not follow. What is this?
my lord, kindly see same person's two application. In one second page, my lord, kindly see first page and second page. In first page, there is no such category mentioned. Got it, my lord? In the second page, after edit, my lord, got it. Same person. It is downloaded from the website.
কোনটা এটা কার এটা
জুলাইয়ের আগে তো তোমরা কোনো কিছু লিখতে দাওনি, 3টে ক্যাটাগরি লিখতে। আমি দেখা দিচ্ছি।
And the same document was shown as OBC. What you showed, it is the same thing.
No, my learned
One of them is
friend
OBC.
says that one of the
One is reservation OBC A or OBC B.
So that is
Cannot ask
different.
for the reservation
That
of
is
EWS. That Mr. Sandal Soul Malad says one of the candidate Malad having OBC, Malad is asking for reservation of
No, what
EWS.
he is showing is that one candidate filed 2 applications. That means possibly one is after the editing, that the category has been incorporated.
Malad subject to correction Malad category Malad since Malad it was pending Malad category probably Malad
26.
A and B for Malad editing, not for the EWS.
EWS, no, one page 166.
There is provision for EWS editing.
First time 160.
Directors are required to mention their category, caste, class, EWS, PH.
It was till 12th of August.
5th August
5th August,
2025,
Our online application.
12th August.
5th August.
OBC মামলা
Please come.
Yes, everyone.
Editing has nothing to do with acquisition of the certificate. A confusion probably is there in the petitioner's mind that edit option means acquiring the certificate.
Malad, and another thing, Malad, this says in pursuance of the Purabi Das,
OBC and
Purabi
OBC.
Das matter, Malad, today, learned senior player not place the OBC order, Malad. Kindly see the OBC order, whether there is any mentioning about that extension.
All right, all right.
Malad, there is no such mentioning, Malad. On the last occasion, I also placed it, Malad. So there is not about OBC, Malad.
Petitioners claim
Report 26.
a reservation under the economically weaker section category.
And
EWS
that order will not be, that order will not be applicable because I approached this court long before, and that too, on the score of that, Malad, they have and Malad, they're not uploaded. We always within 26 September. That is a distinguishable point within the
Memo at page number 166 does not refer Purabi Das order. That's my submission.
দেখুন না
Purabi পরে রেফার্ড হয়েছে,
না আগে রেফার্ড হয়েছে।
সরি,
right.
Purabi Das referred on
Appeared
30
in
July
the
2025.
আচ্ছা অর্ডার বলতে থাকলে তো হবে।
second SLST within bracket 80 examination in response to the advertisement published on 30th May 2025. The last date for submission of the online application was 16th July 2025, which was later extended till 21st July 2025. The fees for the examination was applicable in respect of 2 categories. Not applicable, was segregated in 2 categories. First, for general and OBC candidates, and the other for SC/ST and PH candidates. The note appended to the advertisement mentioned that for consideration of belonging to reserved categories, the candidates, the certificates issued by the competent authorities of only the Government of West Bengal on or before the last date of receiving online applications shall be treated as valid documents. Step. The addendum notices on 30th July 2025, 5th August 2025, and 22nd September 2025, permitting updating/editing the caste category. Stop. Dated 5th August 2025, permitted candidates to mention their specific category, including class, including आगे caste, तारपर class, EWS or physically handicapped category. Stop. The edit option which was provided from 5th August 25 to 12th August 2025. Stop. The case made out by the petitioners is that they applied for obtaining the EWS certificate but due to the delay in issuing such certificate, they could not disclose their category at the very first instance, but the candidates received the certificates prior to the last date of updating, that is 26th September 2025. Stop. It has been submitted that the EWS certificate is valid for a financial year. Stop. These certificates relied upon by the petitioners are valid from 1st April 2025 till 31st March 2026. Stop. It has been submitted that the authority ought to treat the petitioners as candidates of the reserved category, relying on the certificates annexed by them in the instant writ petition. Stop. In support of the submission that the authority ought to give credence to the EWX certificate the petitioners rely on the judgment delivered by the Honorable Punjab and Haryana High Court on 24th March 2023 in LPA 1199-2019 in the matter of Haryana Staff Selection Commission versus Subhash Chand, wherein the court relies on the principle that proof of reservation claim can be submitted later. Stop. The appeal preferred against the judgment in the matter of Subhash Chand within brackets Supra has been affirmed by the Honorable Supreme Court. By judgment dated 31st January 2024 in Civil Appeal number 6395 of 2023 in the matter of Haryana Staff Selection Commission versus Subhash Chand and others. Stop. A reference has also been made to the Judgment delivered by the Honorable Supreme Court in the matter of Dolly Chanda versus Chairman, JEE and others. Reported in 2005, 9 SCC 779. And the judgment delivered by the Honorable Supreme Court in the matter of Ram Kumar Gijroya versus Delhi Subordinate Services Selection Board and another. Reported in 2016, 4 SCC 754. Paragraph: the prayer of the petitioners has been opposed by the respondents. Stop. An application for addition of party has also been filed, has been filed in the writ petition by candidates claiming themselves to be members of the EWS category. The applicants claim to be holding the reservation certificate on the date of the advertisement. Stop. According to them, candidates who were issued the EWS certificate beyond the prescribed time period mentioned in the advertisement have to be taken as ineligible for being treated under the reserved category. Stop. Such candidates ought not to be permitted the benefit of reservation. Stop. Paragraph: Learned Counsel for the Commission submits that the advertisement specifies the date within which the documents for reservation are required to be acquired. Stop. Any document acquired after the last date cannot be relied upon. Stop. In support of such submission, the judgment delivered by the Honorable Supreme Court in Navya versus Union of India and others, reported in 2024 1 SSC 448, has been relied upon. Reference has also been made to the judgment delivered by the Honorable Supreme Court in the matter of Mohit Kumar versus State of Uttar Pradesh and others, reported in 2025 SCC Online SC 1125. Reliance has also been placed on the order dated 26th November 2025, passed by this bench in WPA 26420 of 2025 in Tonmoy Maiti versus the State of West Bengal and others, wherein the court was pleased not to accept the prayer for granting reservation to an EWS category candidate. As the writ petition was filed, now as the candidate approached the court after declaration of the result of the written examination and the interview list. Stop. The paragraph. The judgment passed by the Honorable Supreme Court. Now, the reference to the larger bench made by the Honorable Supreme Court in the matter of Karan Singh Yadav versus Government of NCT of Delhi and others, reported in 2024 to SCC 716, referring the judgment in the matter of Ram Kumar Gijroya within bracket Supra before the larger bench has also been brought to the notice of the court. Stuff. Next. The respondents pray for dismissal of the writ petition. Stuff. I have heard the submission made on behalf of all the parties. Stuff. The advertisement relying on which the petitioners applied for recruitment is dated 30th May 25 for filing the application form and the as extended by the commission was 21st of July 2025. Stuff. As per the reserved category is to be identified considering the certificates issued by the competent authorities of this state. Stuff. In the instant case, the petitioners, now the writ petition contains a chart disclosing when the petitioners applied for obtaining the certificate and when the same were issued by the authority. Stuff. It appears that the process of collecting documents required for obtaining the EWS certificate started after the notice of after the recruitment notice was published. Stuff. Issuance of certificate took some time and the same was issued after the last date for submission of the online application. Stuff. According to the petitioners, as the certificates were issued at a later point of time, accordingly, they could not submit the same within the due date. Stuff. The court is of the considered opinion that had the petitioners obtained the certificates prior to the last date of filing the online application, then they could have got the option of editing their application forms in terms of the addendum notices issued by the commission. Stuff. In the instant case, none of the petitioners possessed the EWS certificate till the last date of filing the application forms. Stop. In fact, from the chart available annexed in the writ petition, it appears that the online application for obtaining the EWS certificate started long after the deadline for filing the online application expired. Stop. If the reservation benefit is granted to the petitioners, then similarly circumstanced candidates who received their certificates after an application may be deprived the scope for being treated as reserved category candidate. Step. The rule relying on which the reservation is granted prescribes that the reservation certificates ought to be issued by the competent authorities on or before the last date of receiving the online applications. Step. The submission of the petitioners that the Commission permitted updating or editing the reservation status does not imply that candidates who obtained the certificates after the last date could have updated or edited their option relying on those certificates. Stop. Had the certificates been available prior to the last date of filing the application form, then only the question of updating or editing the option arises. Stop. Any certificate which is issued beyond the prescribed period cannot be given the benefit of reservation. Stop. The judgment in the matter of Ram Kumar Gijroya mentions about a caste certificate. Stop. A caste certificate. Now, the caste of a candidate and the reservation under the economically weaker section are completely two different matters. Stop. One cannot be equated with the other. Stop. A caste of a candidate, the caste of a candidate is acquired on the date of birth. Stop. The certificate is issued only to certify that the candidate belongs to the reserved category. Stop. By the issuance of a caste certificate, the caste of a candidate cannot be acquired. Stop. Next. In the certificate issued for the economically weaker section of the society, the same is issued relying on the assets possessed by the candidate. Stop. The asset, the same is not static and it keeps changing or vacillating from time to time. Stop. It is for this reason that the economically weaker section certificate is valid only for a period of 1 year. Stop. The certificate is required to be issued afresh if the same condition persists, if the same economical condition persists. Stop. The EWS certificate has nothing to do with the birth of a candidate. Stop. Next. The Honorable Supreme Court in the matter of Mohit Kumar within bracket Supra the court mentioned that after commencement of the process wherein aspirants have participated without raising any demur as to what a particular term means, comma, even if any of the terms be ambiguous, comma, the courts should lean in favor of the recruiting authority. Stop. In Divya within bracket Supra, the court held that determination of eligibility cannot be left uncertain till the final stages of selection, comma, since that would lead to uncertainty. Stop. If rules prescribe the last date on which eligibility should be possessed, comma, any relaxation would prejudice non-applicants who, for want of possession of eligibility, would not have applied. Stop. Selection would then be relaxation, not selection. Relaxation would then be selective, comma, leading to discrimination. Stop. Paragraph. In the instant case, if the prayer of the petitioners for being provided relaxation is allowed, comma, then there may be several other candidates who may have obtained their EWS certificate beyond the prescribed period of limitation would be denied such benefit. Stop. The same and will certainly be discriminatory in nature. Stop. In view of the above, the prayer of the petitioners cannot be allowed. The writ petition fails and is hereby dismissed.
Only one thing is
Can allowed.
Only one
thing
thing.
must be pointed out that the petitioner did not point out. Page number 81 shows a
Yes,
certificate
I want to.
prior to the date of the last date. Yet he applied as OBC B and did not rectify it. That case of petitioner 8 is different from the rest of the petitioners. But page 81, your lordship.
Malal, why I explain that?
18th July. I mean,
Yes.
I
ওটাতে indicate করতে চাইছিলাম।
he has obtained it before the last date. Yet he gave the category of OBC B. Your lordship will find at page 79. The form he has annexed at page 79. So he had option till 5th of August to rectify it. He did not rectify it. That is a separate case, factual situation of the P8.
Malal, may I, Malal? Because of that, Malal, kindly turn page number 81. Sri Ashish Kumar Kole belongs to the Shodgop. Got it, Malal? Kindly turn, Malal, page number 168.
168?
Yes, Malal. Shodgop is a category. Earlier, he was not categorized as a OBC. Later on, the state government of West Bengal, they categorize this Shodgop category as a OBC category, but they not issued the certificate. And for that reason, my lord, kindly turn page number 168.
Yes.
There are FAQ. My OBC status has changed vide new labor department notification dated such and such. What do I enter? My old OBC status or new OBC status? I do not have a OBC certificate as yet, as I am a new entrant. Oblique stroke, my OBC category has changed. My certificate is an old and a manually issued one, and new certificate has not been issued. So what to do? If you have an old certificate, enter that number for future reference and verification. If you are a new entrant and do not have a certificate, leave the field blank as it not a mandatory field. It is made clear that actually physical verification of category details will be conducted only after publication of the result of the written examination. So for that reason, because of that short scope category, my lord, I mentioned it, my lord. And even in my my lord, page number 81, it is mentioned that I am in a short scope category, my lord. I entered my photo and signature. That is, so the reason is that, my lord, because that Shotgop
Then he'll be
community.
treated as OBC and not as the EWS.
Yes.
That can be done. Commission?
That is not the
Not in the REIT, in the commission, whatever is there.
But he has already applied as OBC. If he during verification he could have produced certificate.
Here we are considering only EWS.
Because
his prayer that now consider me as EWS.
No, then whatever he has declared
Yes.
will be.
the reason, because of that, at that point of time, Shotgop was there. Later on,
All right.
new end. Grateful, my lord.
6.
No, I'm for the petitioner. Now I tell you, losses, the application.
This is also SLST matter.
Because
Is this SLST matter?
SLST.
All right.
Up to 10 is SLST.
My application form, page 21.
Yes, 21.
The petitioner applied for assistant teacher in Bengal. I find it at least standard academic qualifications. I don't say too much good or too much bad, but it's good. Your losses will find the column, last column, academic qualifications percentage. See, mentioned percentage went on. Post graduation 7.621. This is percentile, she mentioned. If you losses kindly come to page 12. Total credit value of the program 84 and cumulative grade point average 7.16. He has exactly mentioned as full marks 84 and 7.16. And the second year losses, B.Ed qualification, page 13. Credit value 80 and SGPA, that cumulative grade point average 9.21. Exactly, she mentioned that. The commission at page your lordships, West Bengal School Service Commission, this result published. If you lordships kindly take your lordship, educational
page
22. Rules ta kode.
Yes.
Kindly see educational score 6. If it is converted into percentile, this will be 10. Admittedly, he didn't probably understand that or that. And the cutoff mark 66, that would be 67. Obviously, +4 will be. So this is the point, your losses.
What is the error on the part of the commission?
I've never said,
What you want? No error, petition dismissed. Nothing.
No, kindly at least kindly consider the rules.
What?
Just your lordship, page rules 15. Maybe your lordship have come across in other matters. Joseph, page number 11. I just take your lordship. Oh, 11 to just a minute. 11. No, mistake clause 15. That I. No, kindness. This is governed by these rules. But after Bengali teacher, mathematics weak, obviously she or he will be like me.
No, she is not doing any mathematics.
No, it's a
She is
calculation.
disclosing her
Somebody says
marks.
Percentage, percentile.
Could write properly.
No, that's percentage. That's
Obviously,
here,
that is what
this
is
new marks said
required.
percentile. He quoted the percentile.
Not
In the
fit
other
for-
marks said percentage.
Not fit for the job.
Bengali teacher fit for
Whoever.
this. 15. 15.1. If prior to or after recommendation or during course of selection process, any candidates found to have concealed or suppressed or misrepresented or made false declaration in his application or at any stage, mistake or fault committed by the commission doesn't arise, granting a recommendation rules otherwise, such candidate will be treated disqualified.
Yes.
But he has not concealed anything. See,
she made a false declaration.
this is not declared false, I tell you. Kindly, false is something, something
incorrect.
That I got 2, I mentioned 20. This is false. Whatever I got, I mentioned it. Kindly consider.
Be happy with that.
No, that's two herds views of your loss.
No, nothing.
2 herds. Kindly consider
if
that.
the commission is kind enough to do it, it is on their own, but the court is not going to interfere.
At least direct the commission to consider.
No direction. What is the stand of the commission?
Our stand is, from July to November, there was some window. If we allow this person, to rectify this defect, then a floodgate.
July to September window. Where is that?
Well, he didn't understand the window scope because he thought, he thought that
He thought all were doors closed. No windows open for you.
Well, at least your lordship's window open.
In the 2025 judgment, there's a line which says that one who participates should be vigilant of what is coming next. The notification and advertising.
No, that's not the window. He didn't understand that. He said that I have mentioned whatever in mark sheet.
That is the reason. He should not
window
be
open or not.
Information brochure, kindly comes to the information.
No, I'm not saying that window not. I'm not going into those contention. I'm saying, this is not.
From July to November, there was no approach made. Today we are in the month of December. The interview list and everything is now settled. In terms of your lordship's order, we have clarified in the website.
That is different. That is not in personam. That is in rem. Then
July to November, had he assuming he understood the difficulty, then he could have approached.
Right. See, if
I tell you, losses. This is I got page 22 once come your losses. Let me try your losses whether I can convince.
22.
Now, after I got this, then I tried to realize what happened. Then I found this is the thing. Now your losses kindly see educational.
This is late realization, and the court cannot help.
1 point more.
No, sorry.
6. How could I be assigned 6?
That is between
6,
you and the
nowhere.
commission.
I could have understood they have rejected it. They have not rejected Mala. They have given 6.
Yes.
I could not have been given 6. Because I tell you, losses, why? Kindly have a look at this. Then commission applied his mind. Kindly see. Kindly have a look at this. Page 11.
Page 11 of the
rules. Now kindly see percentage of 10. 60 above 10. If it is converted into percentage, my is 66.6. Then I would have get 10. Now they have given what 6 must be below 50%. I have not got below 50%. How could they give 6?
Below 50, you've disclosed yourself.
No. Your losses kindly look. I have not disclosed percentage. I have given percentile.
The column that you filled up.
That is percentage.
Then
what
they will take it as below. Nothing doing. Sorry, sir. Nothing doing. Please come. The petitioner participated in the second SLST within bracket 80, 20, 25 within bracket class 11 and 12. 11 and 12, just imagine.
I could have made a mistake like this. I'm admitting, Mala.
Nothing
I'm
doing.
an art student, I could have.
Could have. You
and I have made this sort of
face the consequences.
I have faced that.
At the time of filling in
get it,
the application form,
make a study of this.
In the application form, instead of disclosing the marks she obtained in the post-graduation and B.Ed examination, she erroneously disclosed her percentile. Stop. After declaration of the result, she noticed that the uh, the application form was not properly filled up, for which she did not get the marks as she ought to have received in accordance with the score she obtained in those examinations. Stop. Prayer has been made to direct the commission to rectify the direct the commission to permit the petitioner to rectify the error and to consider the actual score which the petitioner secured in the post graduation and B.Ed examination. Stop paragraph. Submission of the petitioner is opposed by the commission. Stop. It has been submitted that a window was provided by the commission to candidates to rectify all errors.
Incorrect, not window. It was open for him to approach the commission from July to November. There was apparently no window.
Then how was it open?
He
Suomoto he could have gone.
approached the commission.
লাইনটা কেটে দিন।
By
আপনি
making
লিখুন,
a presentation.
Yes,
আপনি লিখুন যে
could have approached.
it has been submitted that the petitioner did not approach the commission for rectification of the error prior to declaration of the result of the written examination or the interview list. Stop. After the uh, interview list is published by the commission at this stage, comma, the prayer of the petitioner seeking correction of her marks, not marks, percentage, disclosed in the application form cannot be allowed. Stop. If such relief is provided to the petitioner, comma, similar cases uh, may reach before the court. Stop paragraph. Upon hearing the parties and on perusal of the documents, it appears that the petitioner has disclosed her academic qualification for the madhyamik, higher secondary, graduation, post graduation and B.Ed examination. Stop. In each and every examination, the candidate was required to mention the percentage of marks obtained. Stop. In respect of 3 examinations, the petitioner disclosed her percentage, but for reasons best known, disclosed her percentile in the other 2. Stop. The candidate ought to have been careful and alert at the time of filling in the application form, as any incorrect statement may be treated as an erroneous declaration. Stop. The commission considered the marks disclosed by the candidate as the percentage. Stop. The candidate did not have the opportunity to verify documents at the initial stage. Stop. Because of the difference of marks, comma, the petitioner has not been able to qualify in the qualify for the interview. Stop paragraph. The court is of the opinion that it was for the petitioner's fault that such a problem has arisen, and at this stage to permit the petitioner to rectify the same. Stop. In view of the above, the writ petition fails and is hereby dismissed. Take back the rules. কি হয়েছে? এগুলো পরে দেখান না কেন? ভুলে যাবে। সই হয়নি? সই হয়নি? আপনার ভুল কেন? কি করেছিলেন? কি হবে? Yes.
Lordship, I am appearing for the petitioner's lordship.
Petitioner?
Yes, Lordship. I'm paying for short parcel.
The three matters, 7, 8, and 9. 7 and 8 pertain to a matter similar to my lord's order in Somnath Pramani. Where the category change and general to SC. We have carried an appeal from your lordship's order. Mr. Bandopadhyay in some difficulty today is indicated. May those matters be posted till Thursday. These two matters particularly. And item number 9 for Wednesday. 9 is also very.
Lordship, item 8, Mr. Hall has some difficulty on.
Verification already completed.
And item number 9 has been requested by Mr. Bandopadhyay.
Yes.
Wednesday.
Right. Wednesday.
7 and 8 we are also praying for.
And all three matters are the general 2S.
9 is different.
9 is different, Melody.
All right, then wait. 7, who's for the petitioner? You seek accommodation. There is a request from the commission. I place it on Wednesday.
Yes.
By consent of the parties, take down an order, please. 7, by consent of the parties, list on 10th.
Okay, Lordship, Mr. Thor, I'm praying for not to be on the ground of Mr. Thor. It is similar to this matter.
Then 10th.
10th. Let it appear on 10th.
Some difficulty on 10th. Tomorrow.
Tomorrow the other side will not be there.
This is the same SSC matter, SCSC matter. This is like just like Somnath Pramani.
Yes, it has been carried in appeal. Wait for 2 more days. All right. Same order করে দিন তো by consent Wednesday. 8টা. 9.
Item number 9, Melody, I appear for.
Is it a similar matter?
No.
All right, it's different. 9, there was a request made by Mr. Bandopadhyay to place it on the 10th, Wednesday.
The difficulty is, Melody, verification for 11-12 has already been completed.
All right.
Today or tomorrow, the interview list will be published. But I am praying for a publication of the list of first SLST, other than Melody expiry of panel, OMR, rank jump, all these, Melody. This is my specific prayer, not specifically.
Specific submissions to make, may most humbly be.
Melody, there is a direction from the Supreme Court before this court that this court will ensure. The High Court shall, however, ensure that
Not
none of
tainted candidates. Now it has to be decided who are the tainted and who are.
I am not praying who are the tainted or non-tainted. I am praying for a list. The list will not contain any expiry of panel. The list will not contain any rank jump. The list will not contain any out of panel or any other type of irregularities or OMR.
Yes.
This list may be published.
That means the they have to make categories separately for out of panel candidates, for the after expiry, those OMR mismatch and those.
Those are one categories. The category, my lord, where the candidate do not fall under any of the categories.
Not
Any
specifically
found
tainted.
to be tainted, my lord. This is
But this an order has also been passed. I do
no,
not
no,
know.
no. In respect of my lord, 11, 12, there is no order passed. In respect of Group C and Group D, there is an order passed. But my lord, here is a specification of the category. Let the commission say that these are the candidates. There is a specific prayer, my lord. Let the commission say that these are the candidates who do not fall under any of the category. Four broad categories, my lord, Supreme Court has divided them. One is expiry of panel, one is rank jump, one is OMR mismatch, and one is out of panel, or any other type of irregularity or illegalities. My lord, other than this, a list may be published, because my lord, kindly visualize the difficulty. Interview list will be published. Many person, my lord, we know, my lord, after expiry of panel will be participating. My lord, those vacancies will go. Again, my lord, appointment will be made. So few of the genuine candidates as well as freshers, my lord, they will be deprived of, and they are hurrying up.
Hurrying up because of the Supreme Court deadline. But then, since a request has been made, I'll take it on the 10th only.
10th at the top.
Yes, these matters will be taken up by consent 10th.
But affidavit of service be taken on.
All right, affidavit of service taken on record.
Ten is challenging the rules. Your lordship is already hearing a matter.
Rules challenged by the untainted teacher, not fresher candidate, who are permitted to continue the job till 31st December. They challenge that rule. My lord, only 1 second. Tomorrow, my lord, 1 second, my lord, kindly have a look into prayer. My lord, probably.
Are you participating in this year's examination also?
My lord.
Yes.
Written examination passed.
All right.
My lord, kindly have a look into, my lord, my prayer.
Yes.
Prayer B. Issue a writ in the nature of mandamus, as well as the West Bengal Board of Secondary Education, to conduct de novo examination strictly on the basis of the West Bengal School Service Commission selection for appointment to the post of teachers of 2016 rules. This is our prayer, my lord.
Why? What is the trouble in 2025 rules?
My lord, because of there are so many difficulties, my lord.
What is the offending one?
Difficulties, my lord, decrease of vacancy. My lord, second difficulty, my lord, 100% roster. Third difficulty, my lord, academic score. My lord, suppose I got 94% in Madhyamik. My lord, secondary examination 90%. But graduate examination, my lord, my father died. I got only 40%, 45%. Now 2025 rule, only, my lord, graduate or postgraduate marks in academic, not all through. My lord, intention of the Honorable Supreme Court, 3rd April, 17th April, and 22nd, 26th November, that strictly, my lord, do not hamper the interest of the untainted candidates who appeared in the 2016 rule, 2016 recruitment process. This is the intention of the Honorable Supreme Court, my lord. My lord, if your lordship can
tell me one thing. The rule was published on 29th of May 2025. The advertisement was published on 30th of May. You have filed this writ petition on 5th of December.
It is that already 500 candidates, 500 teachers already left out from the evaluation after written test.
Yes.
Cut off marks, not only that, my lord, poster vanished.
Poster vanished?
Vanished due to 100% roster.
Right.
And not only that, vacancy decrease in physical science. Petitioner number 2 is a physical science teacher. Vacancy decrease total 323 in physical science. My lord, my lord, if your lordship kindly have a look into the order minutely, already, my lord, all senior advocate of this, my lord, court, my lord, demonstrate before your lordship. I am saying only before your lordship the difficulties.
Yes.
Difficulties of 2025 rule and the, my lord, contention of the Honorable Supreme Court 3rd April judgment and section 17 of the School Service Commission Act.
All right.
Now, Your Milord, I want to tell your lordship one thing. Please see page 71.
Today or next day?
Barred.
Today or next day?
The lordship has already dismissed his writ petition on similar grounds. And he did
Not
not
similar
want-
ground.
The principles that we have learned from your lordship is not principles akin to order to rule 2. All issues should be covered in one petition. By multifarious attacks, the commission cannot be questioned for its actions. He moved a writ petition on 2nd of December 2025. My lord was pleased not to entertain his petition. Then he comes by way of this fresh petition, with additional grounds, which perhaps in my respectful submission is clearly not permissible. On that ground itself, the writ petition should not be entertained.
All right.
There are 2 petitioners. There I have not challenged the rule. Here I have challenged the rule.
Why? This is what he is saying. Can
My
you
lord-
come up with multiple writ
No, my
petitions?
lord, not come up with multiple writ petitions. That
Prepared? When?
lord.
Tomorrow?
Tomorrow, day after, whenever suits your lordship. This, I think, we can handle.
If this matter it suits now only, then we can take it up here now.
my lord.
Because you only prayed for adjournment. He is ready.
This question, yes, because
He is
arguing
ready.
Rules, yes, true. If he's arguing rules, the rules matter is coming up tomorrow. Your lordship is hearing Mr. Dhar.
Yes.
Apart from the rules issue, since there is a previous order at page 71, which dismissed his writ petition carried by one of the petitioners, petitioner number 1. In my most respectful submission, this writ petition, if it is
Restricted to two,
I have
nothing.
nothing to say. If it is carried by one once again, the writ petition is at the instance of one is not maintainable.
My lord, defect page 71. Kindly have a look into your lordship's order. The defective prayer. At that time, we do not know the 100% roster. After we came to learn from at the time of the hearing.
What steps did you take to ascertain how the vacancies are declared and all?
That time, page 71, that time, my prayer is defective. For that reason, kindly have a look into page 71, my lord.
Yes.
Page 71 and 72.
Persian.
Petitioner is a teacher of Persian subject.
Yes.
His allegation is that commission
100-point roster is for. Yes, I followed this.
My lord, from the document, the petitioner is a member. According the paragraph 6, prayer of the petitioner for declaring fresh vacancy in the Persian subject in the general category cannot be allowed by the court. It is for the authority to declare vacancy, and the court exercise power of judicial review in such a situation. For that reason, my lord, I challenge the rule. My lord, comprehensive petition I filed.
So this, you did not obtain any leave to challenge the rule. Had you obtained a leave, it would have been otherwise. You
My
did
lord,
not.
with due respect, I am submitting before your lordship. My lord, not a single, my lord, if your lordship kindly have a look into the previous writ petition, the abutment, not a single line regarding my lord rule.
That is what he is
And
saying.
for that reason, liberty, my lord, with due respect, I am submitting before your lordship. Liberty is not, leave is not required, my lord. This is the totally,
I will request my learned friend to kindly go through order to rule 2 once.
my lord, totally different, my lord, aspect. I filed, my lord, writ
But some
petition, my
principles
lord.
has to apply.
My lord, that no whisper in my previous petition.
Whatever you are submitting, your learned friend is accepting that. You cannot come up by way of installments. You have a problem. You have to come in one go, which you have not done. Today you are challenging vacancy. Tomorrow you are challenging the rule. Third day you will challenge something else.
Well, here everything I have, my lord.
This
got up.
cannot be done. Shortcut method, item number, the petition carry forward. You make a choice. Think it over. Come back tomorrow.
My lord.
Followed?
পরশু করে দাও না, কালকে এইসব মামলাগুলো আছে।
Not today.
হ্যাঁ, কালকে যাও।
বলো না, আমার কোনো issue নেই।
Well, kindly keep the day after tomorrow, my lord. Tomorrow, the hearing matters are there, my lord.
All right.
Other matter, my lord, yeah, Bhim matter, my lord. I also filed, my lord, addition of party that was allowed.
Ejaz,
And same,
That is different.
but same argument, my lord.
Ejaz.
So, my lord, untainted teachers, my lord, praying for those, this is an addition of party.
All right. Next. The Wednesday in that case. By consent of parties.
Is the matter.
ওরা করছে তো, নাম দিয়ে দাও।
Not 11, this is 10. By consent of parties, Budbar.
My lord, tomorrow, my lord.
Day after tomorrow.
Yeah.
You get more time to come prepared.
Get fully.
Yes, item 11.
My lord, item 11 is that matter, my lord, where your lordship is, my lord, monitoring that illegal construction over the wetland areas, my lord.
Well, I am the filed one application, corrected application, my lord. We are the flat owners. We have purchased the flats and we are staying there for a long period of time. We made an application for addition of party.
You are residing in flats. Do you have a sanction plan?
My lord, this is sanctioned.
Show me who has issued the sanction plan. Where is your application for addition? Can
Application is number 7, my lord.
Yes, can 7. Show me that you have a sanction plan and who has issued the sanction.
My lord, this sanction was from Panchayat, my lord. On the basis of that, we are shown. My lord, so far this issue is concerned, this ICMA authority. If your lordship ultimately decides to permit me to be added as the party, I'll be taking one point, lordship, that is a point of law. That what would be the force of this act after this National Wetland Management Act has come into force?
Firstly, you tell me what is your legal right.
Legal right, my lord. It was a
Who
Vastu
has
land.
issued the sanction plan?
Panchayat.
Does the panchayat have any authority to issue
My lord,
sanction
kindly
plan?
come to. I have given the development agreement.
Development agreement means
There is
nothing.
no other authority which can give the sanction plan, my lord.
Exactly, because no plan could have been sanctioned over a water body. It's a wetland.
My lord, there are the distinction in the act itself, in the schedule. There are certain area of land which were.
Show me that you fall within those exceptions.
Yes, my lord. If
Please.
I am added as a party, lordship, I will.
You show me now, otherwise I'm not going to add you. I'll dismiss it here and now. Show me that you fall within one of those exceptions where permissions can be granted for
Your
sanction.
lordship, kindly then give me some time. Give me 2 days time. I will give everything. Everything I will give, lordship.
All right.
Whatever I have, definitely.
Obviously.
I can.
One of the panchayats is over here. Which panchayat gave you the authority?
My lord, kindly come to us. I have given my deed of sale, agreement for sale.
Sale you forget. You show me.
Agreement, my lord.
Now, who has filed?
Areas which are not covered by wetland, whether his DAG number falls under this here and
Let him show. Let him show. You serve a copy of the application, otherwise he also doesn't know. Writ petition has to be served. Did you serve to any of the parties?
No, my lord, we have not received.
None has received. There is another application for addition of party. Same thing. They are residing there and they do not have a sanction. Check up the DAG number, plot number, whether it falls within the semi area or not, so that part construction can be provided, part water body, part see, and then make submission. Otherwise, this case is here for quite some time. From 23, it's going on and on. Now, what is the position?
I have a report.
Yes.
If Lordship allows.
How many more identified and
Applications have been made by us, and kindly sees in various paragraphs we have elaborated the difficulties. In a similar matter, Your Lordship, with court number 25 is hearing, there is again an interim order, and the WPAP, which on the last occasion I had mentioned, those applicants have been dedicated before the chief technical officer for giving hearing, opportunity of hearing, because that was I already apprised Your Lordship that they were not there since that, and the Honorable Chief Justice has held that since they have not been given a personal hearing, so this is washed aside and they should give them a fresh opportunity of hearing.
why are you all doing like this? Because see, the act also says that you need to give them an opportunity of hearing. Then there is violation of principle of natural justice. So it means that you are prolonging the whole thing.
No, Your Lordship, they have been given the hearing notice. Many times they have not come up. We have
That is different, but at least do.
in one of the paragraphs there has been an ex parte order which has again been challenged. I would like to.
That is different, but at least y'all follow the rules to identify, to pass an order of demolition. You need to follow the rules.
Lordship, never has there been any violation. You might kindly record my submission.
Whatever, otherwise writ petitions.
Are being served. Even we are taking that precaution that we are affixing the notices on the residences so that they are aware that something like this is happening. Even after that, there is no cooperation.
Do you all have a website, an official website?
I think.
Just wait. In case there is a website, why don't you publish it in the website that the proceeding is going on, and anybody who doesn't have a sanction, these are the plot numbers. See, there are many purchasers who do not know it. Unknowingly they do it. They fall in the trap of these developers and all these people, and then they lose their savings, their life savings.
Yes.
So this is.
I'm beseeching your lordship that after this matter has been in 2023, after that, and when they were very, like lordship had made in her order, she had stated that no further sanction plan will be given, no further electricity connection. This is being strictly adhered to.
Construction is still going on. There are random construction.
See,
I cannot identify those constructions.
So this goes to show, Milord, if he says, I cannot identify the constructions, this goes to show, Milord, he doesn't know whether the construction is being made in a dark number which is substantially water body or partially water body. He must not, Milord.
1 minute, 1 minute. I'm hearing her. Yes. So, whatever has been done, if it is illegal, not in accordance with law, it has to be undone. Let nothing erroneous or illegal be done henceforth. This was the idea, to prevent. Right? Now, I don't know what y'all are doing with those already identified. How many demolitions?
Many have been taken care of, lordship. Demolitions have been taken care.
Yes, show the demolitions.
And on the last occasion, to that effect, report has been placed.
Yes, a wall, a thatched roof. Yes. Those have been demolished. What about the multi-storied?
This is before courtroom number 25. Honorable Commissioner is hearing that
The same property.
The same property.
There may be one property, but you have identified 550 or something, 505 unauthorized illegal constructions.
Apart from that,
Wait. Yes.
Also was there appearing along with me on the last occasion. There is an entry protection. For these entry protections, we are also unable to move.
Interim protections are given only if it is seen that you are doing something not in accordance with law.
But there is slightly different.
All right, then that is only one matter. What about the others?
That is lordship. Whatever has always fallen from your lordship, that big fishes. This is the biggest fish we are trying to catch.
Go to the medium ones now.
there are godowns are also there.
See, he is only saying there are go downs and everything. Go, take steps.
Residential complex, which is being heard over there, they are the hugest residential complex. I think he will not be in a denial mode.
Maybe even if he denies, it hardly matters.
Fortunate.
That very small demolition have been
You
carried out.
demolish only one wall, partly one wall. How does that change the demography, the ecology of that area? It doesn't change.
I do not want to go as of now because I have ventilated in my report what are the difficulties on the last occasion.
Show me one, the demolition, is anything there? See, the last day's order is dated 22nd of September. So we are in December. That is there. But then the order passed on the last day was 22nd November and today we are in December. What is the progress?
Kindly see, your lordship, step by step the progress needs to be. Kindly see paragraph number 1 at page number 2.
Yes.
Page number 2, the last paragraph. The 2 paragraphs I would rely upon. And if lordship is, all the paragraphs can be taken into account. Urban Sabujian, Your Lordship.
1 minute. Paragraph page this page 2, last line I can see. But in spite of repeated requests, the municipal authorities and the district administration are not taking action against those unauthorized construction. This is what you stated in paragraph 2.
No, in paragraph internal page number 2, step by step, Lordship was interested in knowing how we have proceeded, whether it was not in accordance with law or in accordance with law. Kindly please.
No, that is a different bench is looking. Page number 2, the very last line.
Yes, this is what we have. This is one of the difficulties because we do not have the apparatus.
In spite of repeated requests, the municipal authorities and the district administration are not taking action against those unauthorized constructions. I have the municipality here. I have the state over here. Tell me where they have not acceded to your request. Show. Please show. Which letter was not accepted by the state administration or the municipality? Please show.
Kindly please letter dated page number 28. 28/8/25.
28th of August 25. Request to provide an updated status report with the unauthorized constructions within.
And at page 32 also, there is a letter.
1 minute. Request, page 28, request to the corporation to provide an updated status report with respect to the unauthorized constructions within the EKW. Will the corporation be in a position to identify those?
No, because we are passing these orders, we are forwarding it to the either the concerned authority or the district administration.
Where is the order?
Order I have, Your Lordship. I'll just 4/12/2025. Kindly take page 35.
Is the Kolkata Municipal Corporation here?
No, Your Lordship, it has never been represented.
No, it is not a party in this process.
Not a party also. All right. Page
25.
I appear for the district administration.
Yes, that I am aware. Page, which page did you refer to?
25. 4/12/2025. My recent order.
And this is in respect of the Kolkata Municipal Corporation. Where do I get that?
Taking into consideration conclusion at page 37.
Yes.
All the aspects. The
Can I get you?
opinion that the applicant illegally constructed boundary wall, tile toilet, storeroom, concrete pathway under Keha Daha Gram Panchayat district. The aforesaid activities are illegal and violate provisions of section 9 of hence the applicant is right to restore this honorable breach.
No, it's forwarded. Right. It is where from will it be understood that it is the Kolkata Municipal Corporation has to act? Because this is on the Keha 2 Gram Panchayat it is mentioned. Then why will the corporation come over here?
There is separate with corporation also. Either the corporation has to do it if it is a corporation area or the district.
Keha, are you for the Keha 2 Panchayat? Keha Gram Panchayat. Page number today a report has been filed. A copy
I am
will
a Jila
be...
Parishad, but I am a.
Oh, you are not the Panchayat.
Jila Parishad.
You are for the Jila Parishad.
Jila Parishad, na?
Very well. If you are the Jila Parishad, you can always take care of the Panchayat authorities. The block development officer, you please ensure that this order is being acted upon. A copy, please wait. A copy will be given to you. Please check up. Keha 2 Gram Panchayat is involved. And the next one, page 39.
39 is another construction.
Yes.
This is another construction.
This is also Keha 2 Panchayat.
This is also. Corporation also I have the lordship of the located at not this point of time.
It must be there. It has to be there. And this order is passed only on the 4th of December 2025. So it's a very recent order. Have you served this order upon the... Right. So this order is required to be served upon the... No, not only here, the persons who made the construction, persons responsible, you have to serve. They have? Page 35, 38, I can see copy forwarded. Now, whether it has actually been forwarded or not, you have to check. Please do.
Whether they are aware, because at that, when the hearing is only going on and when sanction plans are also not produced, since many of the persons who have been given opportunities of hearing, they are full aware of the actual situation which is prevailing at the ground. So I don't think anybody who is participating in hearing and who is being given notice is absolutely in the dark that this is not an illegal.
Nevertheless,
They're very smart.
to avoid the allegation of violation of principle of natural justice, put it up in your official website that these are the plots where no construction is permissible and any construction made thereon will be demolished in accordance with the act itself. So that way at least you can take care of the principle of natural justice. Thereafter, individual notices you'll certainly give because the act requires a notice of hearing to be given, right? And show me something that you requested the state to provide you some. If it is here, then I can direct the state.
It is here itself. Copy forwarded to. There has been Mr. Chatterjee is in a clear. He will be able to apprise your lordship more clearly than I should have. There is a change in the office of the district magistrate. Some new incumbent is there.
That hardly matters. The office remains.
I will follow it up.
So, whatever is required to be done, because till I see some demolition taking place, not me seeing it, the people seeing it, the people cannot repose faith on the judiciary, on the administration, which is extremely disturbing.
May I only say this, my lord, 90%, my report says the 90% of godowns are already demolished over the entire area. 90% of the same has been demolished pursuant to my lord's.
Go down.
No, I have to
go down.
It's very, very easy to comment from behind.
Will never be demolished.
I understand. Go down. How many are there? Nobody knows.
Comment from behind, my lord. Big structures have been used.
Maybe.
And at last I found this sanction plan
Yes, show me.
annexed, which is in page number 54, right hand corner. Lordship, this Mauza Jagipota is there and the dark numbers are there. My lord, page 54.
Yes.
P2 is the sanction plan. Kindly come to the right hand top. Proposed G+2 storage residential apartment block at scheme number such and such under Khatiyan number 17, 18, dark number 37 under Khatiyan number such and such. Now, Lordship, this can be compared with the schedule. I have compared. It is falling, Lordship. I have to recheck it and verify it. I just
Falling within which? The
schedule, Lordship. That I will again verify. I just at a glance I have verified. Schedule 9.
Within the wetlands.
Wetland, within not within. There are 3 categories.
Yes.
The portion of that has been identified as the substantially wetland. Others are settlement area, Vastu area.
Under which land does your sanction plan fall?
Lordship, this Vastu area. Lordship.
Check up. Check up.
G+2 is not office of Gram Panchayat, Lordship.
Yes.
1.1.
Right. How can such a is going on sanction? Absolutely illegal. It cannot be done. It cannot be done.
That has been done. That has to be undone. But Lordship, here, this is a case of Lordship ECMA Act, Lordship, but this was coming in my mind, that this cannot be done in the way it is done under the municipal law. It has to be done, Lordship. Lordship may keep the principle of polluters pay also in mind. The constructor, those who are engaged in the constructions. This is a case, Lordship can apply that doctrine and make them liable to pay.
That is different. That is different. What doctrine to be applied is different. Thing is, Let us see whether your structure has been identified. There is a list of
Yes, so that
structures.
may I be supplied with those copies. I will identify and come back. 505 so far, 505 constructions has been
Identified.
My lord, let those that have been identified not only publishing in the website. I tell your lordship practically, no purchaser goes to the website. It will be published in the website along with the English and
Newspapers?
Bengali newspaper, the plot numbers and the name of the owners. So these are not within the permissible. You cannot construct. You contact us and separate notice will be given. Otherwise, my lord, this will continue forever, never. And my lord, only
both of us, electricity authority,
Also, same submission.
Same submissions.
I understand because website nobody. Nobody.
Paper public.
Paper publication.
Problem will never be solved, my lord.
All right.
And my lord, no big apartments, not a single one has till date been identified and demolished. Only small walls.
I'm following under this. Yes, this is the court.
Entirely, your lordship. Our urban Sabujian, my most.
Only one, my lord.
Why are you targeting him?
Why you always have to choose that? When we have to choose that, you are now.
There are many.
Many. And now he's going out.
My lord,
My lord, I am falling within the settlement area, my lord.
Just
record my
wait
submission.
for the maturity of this
Many which
matter.
they have not.
My lord, I am
A
falling within
position
urban
is
slash rural
You all
settlement.
today you are coming up with a proposal for SIT. Now it will be it will come from authority only. State will also prefer one because otherwise, see, the corporation is not a party. Corporation is required to be implemented as party over here. The Kolkata. Please do. Otherwise, you cannot get hold of this whole thing, right? Please.
My lord, I checked up, my lord. It is there. Urban rural settlement.
Filing an additional part.
Because you have made because I feel that you are going to demolish it.
No, if that way you cannot be done. You apprehend that something will happen. Yes.
This is it's an apprehension in REM, my lord.
Are you coming up with an affidavit or report today?
I have a report.
Please give. Report file.
Handing over one to. I'm handing over one to the petitioner, your lordship.
Please do.
Please receive it. What should I give you? Your lordship.
Whatever reports are submitted may it be circulated.
Each and every day I pass this order, reports to be circulated.
Pay your lordship.
No, I understand, madam. There may be some difficulty, but if we have not got any report, let us
Then ventilate the date. I will serve a copy of
report was not supplied. To us also not.
Report filed by the EKWMA and the state administration in court today be written with the records. Stop. Let copy of both the reports be circulated to all the parties. Stop. In the event any of the parties do not receive a report, it will be open for the advocate on record to intimate the same to the learned advocate representing EKWMA and the state for circulation of the report. Anybody who doesn't get it, please communicate so that it can be served. At least soft copies provide. Next. It appears that large scale unauthorized constructions have been made over the East Kolkata wetlands in flagrant violation of the act and the rules. Stop. The authority and the state are grappling with the difficulty to get rid of the unauthorized constructions. Stop. Paragraph to make the public aware about the unauthorized constructions made over the wetlands, EKWMA is directed to publish in its official website and also in leading newspapers, both in English and vernacular, clearly disclosing the plot numbers over which constructions are impermissible under the Act. Stop. Any construction made over the plots / dag numbers where construction is not permissible is liable to be demolished. Stop. The authority, the state administration, the municipal authorities are requested to act in tandem to ensure that the provisions of the Act are strictly followed and no unauthorized construction is permissible over the, is made over the wetlands. Stop. The service providers, namely the electricity and water service providers have already been restrained from providing any new connection to any of the premises constructed over the wetlands. Stop. The hearing of this matter stands adjourned till 23rd of February 2026. Stop. The progress report of the authority and the state shall be placed before this court on the adjourned date. Stop. Leave is granted to the advocate on record of the petitioner to implead the Kolkata Municipal Corporation as party respondent in the instant writ petition and serve a copy of the writ petition upon Mr. Shapon Kumar Debnath is the person, isn't it? His name is? Learned advocate who represents the Kolkata Municipal Corporation before this court.
I believe all the copies of the orders, because your lordship has passed so many orders.
Yes, all orders are there in the server. Anybody just clicks will get to see everything.
But your lordship knows better.
People have to upgrade, especially when lawyers are there, they can always help. Right.
My lord, only one submission, my lord.
Yes.
My lord, there is a restriction upon the electricity board as well as the water supply authorities not to give such thing. My lord, registering authority till date, my lord, my client has instruction that, my lord, new flats are being constructed, the development segment are being registered. My lord, there should be an order by the
registering authority.
All the registering authorities.
The registering authorities. Now, this order has to be communicated by the state because here the Registrar of Assurance has
they cannot refuse. Not only Registrar of Assurance, it should be RA as well as PSR and
the authority over there.
Department of
Isn't it? Yes. Right, because I remember passing these orders.
There was an order. There was already.
So far, my addition of party application is concerned, my lord.
There was an order.
Page.
There was an order.
My lord, but these are to be communicated to the registering authorities. ESR, ADSR and RA.
24th of
February.
That means long back this was passed.
These should be communicated to the respective DSR and ADSR and RA.
No, ideally upon IGR. Upon IGR.
The Registrar of Assurance and everybody has been restrained.
IGR has to be communicated.
The registrar of assurance and the district registering authorities have already been restrained from registering any structure over the wetlands. Stop. The Inspector General of Registration.
Yes.
Learned advocate for the state respondents is directed to communicate this order to the Inspector General of Registration for onward communication to all the registering authorities, not to register any property where construction is being made over the wetlands. ঠিক আছে
My application